If you have a minor child, or if you know someone who has a minor child, maybe you're the grandparent of a minor child, this video is for you, because today we're talking about how to name a guardian for a minor child in your estate plan, whether that's a will or in a trust. Now, it's very important that we consider who to name as a guardian, because if you don't have anyone named, if you don't have an estate plan, or if your estate plan does not name a guardian for minor children, a court is going to decide who the guardian of that child should be in the event something were to happen to you. And that may or may not be the same person that you would want to choose. This court, this judge does not know you, your children, your family, and is trying to make the best decision it can, but the best person to make that decision is going to be you, if you are the parent of this minor child. And so for a minor, we're talking about anyone who's under the age of 18. Now, when the child is a little bit older, in their later teens, they could have some input as to who is selected if you have not decided on someone. But it's really best, and it's really, I tell my clients with estate planning, one of the best gifts you can leave to your family, to your children, is a well thought out estate plan. It doesn't have to be complex. It doesn't have to be complicated. It doesn't have to be overly expensive. But we need to have a plan that lays out what happens in the event something happens to you. And so when naming a guardian for your child, when I'm having a consultation with my estate planning clients, sometimes the clients may have someone that they are inclined to select. We want to ensure that that person that you named is willing to act as guardian for your child or children if you have more than one in the event something happens to you. And then also consider where your child is going to live. If it's going to be maybe a sibling that you're naming as guardian, if that sibling lives out of state, then you may want to think about your child would likely then be moving out of state to that location. Now, that still could be the best solution and the best guardian for your child, but it's something to just consider, right? Because at that point in time, if something has happened to you, and if you're married or there's a partner to them as well, and your child is now being placed with someone else, even if they do know that person, having to move out of state or change schools, there's going to be a lot of changes and disruptions to their lives on top of having lost one or both parents, right? And so we want to make sure we're considering the location of the named guardian. Again, if that guardian is willing to act in that capacity for your child if something were to happen to you, looking at any, values, the relationship that you have with that person, the relationship that they have with your child, if there's a relationship already, their ability to provide stability, right, for the child. And so these conversations are never easy. And they're not ones that my clients really want to have. And I understand that. I have 2 minor children myself. And so I understand that. But I will also say, having been on the other side of things where I've been an attorney for in situations where there wasn't an estate plan, there was no will, there was no plan, there was no named guardian. And now these decisions have to be made by people who may or may not know what's best for you and for your family. And so I tell my clients, again, that the best gift you can leave is an estate plan for your family, no matter how big or how small your estate may be or that you think that it is. If you don't have your own plan, the state of Washington has a default plan for you. And that may or may not be what you actually want for your estate plan. So the only way to ensure that what you want to have happen actually happens is by doing an estate plan. Now, I try to make it as easy as possible with my office. You reach out, we schedule a consultation, we can do it in person, over the phone, over Zoom, whatever's easier for you. You retain us, we draft your documents, you review them. I can either make them available to you in an online portal for you to review. I can mail hard copies to you. You can pick up hard copies from my office if you're local to me. And then once you've approved them, you come in and we sign them. I provide a witness, I provide a notary, we do everything there for you. So I try to make it as easy as possible, but there are going to be some tough decisions that you have to make. Now, I'm here to help you and to guide you and to give you my input. and based on, kind of what I've seen, what other clients do. So I'm here to guide you and support you in this decision-making process, but I want to make it as easy as possible for you. I don't want there to be a lot of hoops and obstacles to jump through. I know it can seem very overwhelming to pick up the phone and call an attorney's office or to reach out through text or email. I know, again, this is not a desired conversation that really anybody wants to have, but it's an important one that we have. So I do what I can to make it easy as possible for you. So if you are in Washington State, if you need help with your estate plan, if it's one of those things that you've been putting off for a number of years and you know you need to do it, I am here. I'm happy to help you. I'm Darcel Lobo. I own Dow Law Firm here in Normandy Park, like South King County area here in Washington State. So I'll put my contact information below, our email, our phone. You can call or text us. If you are outside of Washington, I would love to help you, but I'm only licensed in Washington State, so I would not be able to help. But if you're in Washington and want help with your estate plan, please reach out. Thank you and have a great day.